Hi, my name is Andrew Kinney. I'm an attorney at Hogan Law Offices. I'm an attorney that has focused my practice on Social Security disability law and SSI cases for over 20 years. This is Social Security 101, my attempt through a number of free videos to describe to anyone that needs to understand how the process works and uncover some of the detailed law underneath it. I don't want people intimidated by the Social Security process. If you can represent yourself, that is excellent, but ultimately, no matter what one does, if you don't feel well, it is good to get help with someone else for whatever you do. With the Social Security claim, it is good to seriously consider getting help, and since Social Security is in the regulations, there's law involved. So if you choose to get help, think seriously about whether you want a lawyer, and non-attorneys can do this, and non-attorney national firms do it, but the question is how versed is the people and the person you're going to have with you in the law. So today I'm going to talk about the key part of any Social Security claim. You have the application, reconsideration, then you have a hearing. At a Social Security hearing, I'm going to discuss what happens. At a Social Security hearing, at that point, you may have been waiting a year and a half or so, depending on where you live in the country, and there is a Social Security administrative law judge that's assigned to you. Social Security calls us, writes you, or calls the attorney that's of record and says, we have a hearing coming up. They have a mandatory 21 days notice, but they generally, and it's ideal if they call you earlier to allow you to get records, if they call you within 6 or 8 weeks before the hearing, that's ideal. Hearing officers listening to this, that allows people to have time to get the records. But the Social Security schedules this hearing, and let's say you have an attorney. You and your attorney will discuss your problems, what issues need to be addressed, and then at the hearing it's 1 hour, roughly. It can be a little less, rarely a little more, and you have an exclusive time with a judge, either in person or by video, to discuss what problems you have, how bad they are, when you last worked, whether you've looked for work, and also what you can and can't do each day, your limitations. The point of the hearing is that you're able to talk directly with the decision maker from Social Security. The first 2 decisions from Social Security are actually from a state agency, not Social Security proper, and with the state agencies, they deny people without talking with them, or even, for that matter, interacting with them very much at all, except through forms that they create. What do you expect will happen? So at a hearing, a majority of cases naturally are overturned. And the reason is because there are bad decisions made at the first 2 levels, and that's been the case for a while. The goal of the first 2 levels is to filter out and deny, with some exceptions. A lot of legitimate cases need to go to hearing, and they shouldn't. But at a hearing, when you get there, your attorney and you go in and discuss with a judge under oath what's wrong with you, and they're experts in the hearing. Always a job expert, almost always, and sometimes a medical expert. You're explaining what's wrong. Your representative is not only explaining the law that applies, but also cross-examining those experts. So ultimately, whatever help you get at the hearing level is crucial. Make sure the person helping you has been doing this for a while. Ask how many hearings they've done, how long they've done hearings, because in the end, the experience may make a difference in whether you win or lose your case. If you have any other questions about Social Security or hearings in particular, just call the number at the bottom of our screen. Thank you.